Hey guys, there are some crazy cases going on right now, and I'm talking about particularly the Darrel Brooks case, the guy who used his vehicle to run over and murder innocent women and children in Wisconsin. His trial has started, and he's representing himself now, and if you haven't watched clips of that, you should, because it's all of it is absolute insanity. So I thought, why don't we look at what is the role of insanity in a criminal case? Can someone get away with murder if they're insane, not guilty by a reason of insanity? So let's look at 3 points in the law in a case of a defendant where being crazy matters a lot. So the first one, everybody's heard of this, is not guilty by reason of insanity. That's simple, right? If you're insane, you're not guilty. How hard can that be? Let's shut this video down. It's not that simple. Remember when Bill Clinton said it depends on what the definition of is? He said that because he's a lawyer. And in the case of not guilty by reason of insanity, well, that depends on what the definition of insanity is. And it's not really what you would think. So let's give an example of that. Let's talk about Jeffrey Dahmer, who loved having people over for dinner, right? So that's crazy. That's just absolutely crazy. He's crazy. He's insane. So he must be not guilty, right? No. If that's all it took, then the crazier the murder, the more bizarre the circumstances of the murder, the less likely the person could be to be found guilty of it. So that's not how insanity works. And I'm going to focus a little bit on North Carolina law, but it's generally similar across the nation, although there are tweaks in various states on how insanity sorts of defenses and mental capacity really is what we're talking about here, how those defenses work. So in North Carolina, we basically follow what's called the Mcnaughton Rule, which is an old doctrine which says that in order to be found insane for purposes of criminal culpability, you have to either not know what you were doing, the mental condition you have prevents you from even knowing what you're doing. And then secondly, it could be that you know what you're doing, but you didn't have any idea that it was wrong. You don't know the difference between right and wrong because of this mental issue you have. So on its face, of course, you might think none of that should matter. If you kill somebody, you should be punished for it, and I get that. But the idea of your mental state mattering in the law, in a criminal context, and even often in a civil context, that goes back forever, basically, in the kind of law that we have. And think about it. If I rear end your vehicle and it's an accident, and my foot came off the brake by accident or something like that, or I just didn't see, it wasn't on purpose, that's one sort of act, right? But if I see you on the road and I accelerate and I rear end your vehicle as hard as I can, totally on purpose, that's worse, right? And the difference is really my intent behind that. So the intent matters a lot in the law. So we got to figure out sometimes somebody's intent depending on the crime they're charged with. And behind that is whether they can have that intent, whether their mind is functioning, if we're going to hold them criminally responsible. So that's the idea behind the insanity defense. So let's look at how it works. So we'll just get some hypotheticals here. Remember, of course, any jury can see this differently, so I'm just making these up off the top of my head. Let's say you're on the street and the voices in your head tell you that the person you see across the street is not, in fact, a person, but is a demon transported here from another realm to kill everyone, that humanity's existence is at stake, that it's not another person over there. And you don't think that it's wrong to destroy a demon. You just don't have any idea about that. So there's nothing wrong in getting rid of it. In fact, you'd be doing a great service for society. So you shoot the demon and it's a person. There's a possibility there that while you knew what you were doing with the gun, that it may be concluded that you simply did not understand that there was a right or wrong situation there, that you were in fact breaking the law, because is there a law on interdimensional demons? I mean, not that I'm aware of necessarily. So you don't even know that what you're doing there is wrong. Potentially, that's an insanity defense. So that's a little bit of what I'm angling at there, is you lack the capacity to know right from wrong, that what you're doing is a wrong thing. Now, it gets raised in cases like the Jeffrey Dahmer case and many other cases as well, that, hey, this guy was obviously super crazy and didn't know what he was doing right or wrong. And the prosecution will attempt to rebut that by showing if he didn't know it was wrong, he wouldn't have tried to hide it. So there was a lot of pre-planning. There was a lot of trying to keep it secret. that sort of thing, to show that, no, this person didn't think this was innocent. They knew the law was against this. So even if the voice is telling you, let's say the voice is telling you, shoot this person across the street, that will prove your loyalty to me. I am the interdimensional figure, and I'm communicating to you that I will reward you if you shoot this person across the street. So you shoot the person because you think that's what you're supposed to do, and then you run away and you throw the gun in the water and all that. Well, the voices aren't getting you off there because you knew what you were doing was wrong. Okay, yes, you were crazy when you did it, but you knew it was wrong. And that's kind of the situation, say, with Jeffrey Dahmer, that, yeah, he's obviously crazy, for example, but he knew what he was doing was wrong. He just did it anyway. So that's a pretty material difference. Otherwise, all the whack jobs would get off of their convictions, and they'd all be doing whatever they do once they're found not guilty. So let's say you are successful and you're found not guilty by reason of insanity because the voices convinced you that what you were doing was not wrong, and everybody believes that. What happens to you, right? You just get to waltz out of the courtroom and do whatever you want to do after that? Not really. So in this state, if that's the case and you're found not guilty by reason of insanity, they're going to say, well, you're insane, so we need to help you, and they will commit you to a facility. And there are various people in these facilities in North Carolina who have murdered people. Not many, but let's take an example, Wendell Williamson. He killed people in Chapel Hill and was committed and tried to get out over the years, and he couldn't do it because he couldn't convince them to release him. Remember, he's not convicted of a crime, right? So he's innocent, but he's held involuntarily in a secure facility. The idea being that he can't be let out until either his mental condition is cured and or he's no longer considered a threat to other people. He's unlikely to commit the kind of harm that he committed in the first place. And if you can't do that, then they're going to keep you there. And obviously, if they made a practice of letting people off because they were insane and then just letting them back out into society, this would get modified further, and they don't want that. And they don't want dangerous people on the street. So generally, these people spend a lot of time in secure facilities, almost as if they had been convicted, except receiving the medical care that they need, right? So if you're crazy, that's potentially better than just being sane when you murder people, because there's a possibility you could talk someone into letting you out of this mental facility. But it is not a free ticket almost anywhere. Again, this can be different across the country, but what my point here is that the definition of insanity from a legal perspective is not the common definition of insanity of just being absolute bonkers. It's very specific that you can't know what you're doing, or you can't understand that what you were doing was a right or wrong situation. You have to show that. So that's pretty substantial. It's subject to abuse, but it's not widespread because of the narrow definition that's typically employed by most states. So the second instance is, and now you're going to trial, like, say, Lori Vallow. So she may still have an insanity defense coming up, I don't know. But the point here is that she's in the second phase of where craziness is important, and that is in your capability to proceed to trial. Are you incapable of doing that? And the judge has recently found that that is the case for her, so her trial is suspended. So let's talk about what happens if you're found to be incompetent. It's kind of the old word, but there's incapacity to be at the trial. That's the new doctrine. Let's see how that works. For incapacity to proceed, here at least, you need to show that you don't understand or can't understand the nature of the proceedings against you, or you don't comprehend the situation that you're in, or you cannot assist in your defense in any kind of rational manner. If you can show that, or if your team can show that, then you could be found incapable of standing trial. What happens if that happens? There are different things that can happen. So in North Carolina, basically, if you're under, say, indictment for a violent crime, whether because you are suffering from these defects at this point, they're going to send you to a secure evaluation, and you may be held there until you can proceed with the trial that you can understand. Maybe they'll get you some drugs or get you detoxed or whatever the problem is. They'll help you with it, and then when you can, you'll come back and go to trial. They could also, in less serious cases, they could put you out on bail or release you with some kind of conditions and bring you back later, check in on that after maybe some treatment or something like that. They can dismiss the charges. If it's a very nominal thing, they may just decide, we're just going to let this one go for now. It's not serious and not worth the time and the effort to proceed against it. Also, if you're confined while they're helping you, then the charges may be dismissed if the period you're confined for would be equal to the maximum sentence of what you'd be tried for in the first place. And that seems kind of fair as well. So if you're incapable of standing trial, that may be a free ticket for you, but probably not. Probably not, especially in a violent crime instance. You're really just going to delay the trial. So that's what's going on with Lori Vallow right now. The judge has suspended this, I think, while they're checking into this due to probably some of her crazy behavior. Is she crazy? Is she mentally defective? Yeah, because she's been involved in several murders, I think, at least, and 2 of those involving her own children. So that's terrible. So anyway, the idea under the Sixth Amendment is you can't put somebody on trial if they don't even understand what's going on around them. But that doesn't mean that you just get to leave the courtroom once they decide that you're incapable of that and go back to hearing voices and killing people again. That's not necessarily a free ticket, but it is a roadblock to getting you convicted. So if you weren't crazy at the time you committed the murders, but then you become crazy enough or some problem happens to you that you can't understand the trial, then you are going to succeed likely in getting the trial delayed at least. So let's look at the third time when the craziness can matter, and that is, okay, you're not able at least to get off right away for this insanity thing. Maybe it's a defense, you're going to have a trial. You can't show that you're incompetent to stand trial. What if you want to represent yourself? What about that? That's what's happening in the Darrel Brooks case. So if you're competent to stand trial, then you should be able to represent yourself, right? That's the end of the story, right? You've got a Sixth Amendment right to represent yourself if you don't want appointed counsel or to hire your own lawyer. But it's not exactly right, because you have to be able to knowingly understand what waiving counsel means and at least demonstrate to the court that you're going to be able to function in some way in the court proceedings that makes sense. So there is the possibility that you could have a mental defect that doesn't quite prevent you from being competent to stand trial, because there you just need to be able to assist in your defense and understand what's going on, but which could be debilitating to keep you from effectively representing yourself and even understanding the danger that you're in. And that is certainly the case if the judge thinks that you can't understand really how the proceedings are going to work procedurally, how the legal system works. Maybe you can't control your behavior for long enough lengths of time to stay focused, to defend yourself. That, something like that could convince a judge that, look, you can stand trial, but you've got to have a lawyer. Now, they're going to look at it hard because of your general right to represent yourself, but they're not going to allow it to occur if it would be considered essentially tantamount to putting someone on trial who is incompetent to be there in the first place. So there are limits to that. But if you're wondering how Darrel Brooks is representing himself when he obviously is trying to disrupt the court and also probably is to some degree crazy, well, that's how he had to convince the judge that he could understand what was going on, that the dangers of not having a lawyer, how the system was going to work. And really, he kind of does understand that. Even though he's being disruptive, I think he's being disruptive in a way that shows that he knows what the process is, even if he is not doing well at it. And it's certainly the case that when you talk to people, and especially online, that they think that, well, I've watched a lot of courtroom TV and stuff like that, and a lot of lawyers are bad, so I'm just sure I could do a better job than that. But you may be proceeding with a great deal of ignorance as to how the legal system itself works. Not that there's no one who can do a great job of representing themselves. I'm not saying that at all. And I'm not saying that sometimes lawyers don't do a horrible job in trial. If a trial goes to a jury verdict, 50% of the lawyers in the room pretty much have just lost the case. So there's always a case to be made that maybe I could have done it better myself. But I think an appreciation of that has to be accompanied with the fact that there are a lot of things that go on in a case beyond just the experience an attorney can bring, but just the technical things that can go on, the things that could be a defense for you or allow you to maneuver the case in your direction that you're never going to think of because you've never studied it or thought of it. And that is not the system being rigged against you. That's true in everything in life, from whether you're working on your own car, going to pull your own tooth instead of having a dentist do it, build your own house. That experience matters and knowledge matters, and your ability to get your mind around what you don't know so that you can learn it also matters. And if you proceed into anything serious, assuming you already know how it all works, and anything that doesn't comport with your prior understanding just indicates a system is rigged against you, you're probably going to do a poor job. I don't think those are the kind of people who be successful. The successful ones are the ones who learn what is at stake in the system and how to operate it. And that can be done through experience with a licensed person or a dedicated smart person or some conjunction of the two. But anyway, that's what's going on with Darrel Brooks and why his courtroom situation is absolutely bonkers, where he's in the court, then he won't shut up, so she kicks him into a different courtroom where she can mute him, and he holds up the blue sign to object constantly. It's kind of a farce, and she's proceeding very slow with a lot of deference to him, but that's, I think, to be fair to him, and also so that in the event of a conviction, he's not going to be able to appeal it and say, well, the judge didn't give me the opportunity. She just threw me out for no reason and therefore unfairly hampered my defense, because she is certainly not doing that. And she is definitely completing a record that's going to support how she's conducting the case so far. In fact, she's leaned over very far for this guy. It's awful because the evidence is out there that he intentionally drove over these people, hitting as many innocent people as he possibly can. For whatever reason, he wanted to do that. And now this trial is going to be a little bit of a farce because he's representing himself and he's using that as an opportunity to disrupt things, although he was a little more restrained in his witness questioning yesterday. But if you have a chance, I'd go on Law and Crime's channel and watch some of the clips of that, because it's pretty crazy. It's one of the crazier things I've seen lately. So that's a summary of being crazy in the law. Does it let you get away with a crime? Does it keep you from having to go to trial? And what if you want to represent yourself? It's all laid out there. Have a good weekend. Thanks. Bye.